Greetings, my name is Clive Chiuzu. The short clip you've just seen illustrates an unfortunate reality that's currently facing Malaysia's youth, which is child grooming. The British National Society for the Prevention of Cruelty, the NSPCC, defines child grooming as the act of someone, male or female, building an emotional connection with the child to gain their trust for the purpose of sexual abuse, sexual exploitation, or trafficking. Child grooming has unfortunately become all too common in Malaysia, expedited by the growth in popularity of social media as well as the increase in the number of minors joining such platforms. The New Straits Times estimates that 80% of the reported cases by predators in Malaysia over the past 2 years involve internet acquaintances, with the majority of the victims falling below the age of 18. Therefore, it is in the best interest of the state and its children that there are sufficient laws protecting children from these unfortunate circumstances. With that said, the purpose of this video is to discuss whether the provisions pertaining to child grooming in the Malaysian Sexual Offences Against Children Act 2017 have been drafted clearly and provide sufficient protection to minors against sexual predators. I, along with my fellow group members, Shaista, Sumaya, and Asdeen, will present our findings on this matter. First, let's look at the provisions that outlaw the practice of child grooming. Child grooming is defined under Part 3, Section 12, Sub 1 of the Offences Against Children Act 2017. It states that any person who communicates by any means with a child with the intention to commit or to facilitate the commission of any offence under Section 5, 8, 14, 15, or any offences specified in the schedule commits an offence. Looking at these provisions, one can easily ascertain the mens rea and the actus reus of the offence. The mens rea could be said to be the intent to commit or to facilitate the commission of the crimes in the sections mentioned earlier. The actus reus could be submitted as being communicating with a child by any means. Section 2 illustrates that for the purpose of the act, a child is a person under the age of 18. With that said, the definition of sexually communicating is provided under Section 11, Sub 2, where it states that a person is said to sexually communicate if the communication or any part of the communication relates to the activity that is sexual in nature, or a reasonable person would consider that any part of the communication to be sexual. The law does, however, provide exceptions to this. By virtue of Section 11, Sub 3, a person would not be said to sexually communicate with a child if it's for education, scientific, or medical purposes. Furthermore, Section 13, Sub 1 makes it illegal for any person to meet a child following grooming. Any person who, having communicated by any means with a child, travels to meet with or meets with a child with intention to commit an offence under the Act can be subject to whipping or imprisonment not exceeding 10 years. Therefore, the actus reus to be proven for this offence, it must be shown that the accused had communicated by any means with the child, which means grooming must have occurred. Additionally, he must have traveled to meet or met with the child. The mens rea could be submitted as being the intention to commit or to facilitate an offence. Now, it's also important to look at Section 16, which provides for, or rather supplements situations where grooming happened in a relationship of trust. Sub 1 of this section illustrates that if a person commits an offence under the Act, in this instance grooming, against a child, where the relationship is of trust, such person will be liable, in addition to the punishment under the relevant section, will be liable for a term of imprisonment not exceeding 5 years and no less than 2 strokes of whipping. Sub 2 of Section 16 further identifies what the law regards as relationships of trust. These include a parent, a guardian, a person related through blood, marriage, or adoption, a teacher, lecturer, a coach, etc.
I will now look into the positive aspect of child grooming and other related provision under the OAC 2017. Although unstated substantially late, the new OAC has commendable provision protecting children from sexual predators where it pertains to sexual grooming. Taking into account provisions Clive stated earlier on, another notable provision in relation to grooming is the extraterritorial application of the grooming law found under Section 3 of the Act. This section illustrates that if any offence is committed by a predator in Malaysia or outside the territories of Malaysia, the latter will still be punished as if the offence had been committed within the territories of Malaysia. This provision plays an important role since most cases of grooming take place online. The provision under Section 3 of the OAC 2017 ensures that the location of the predator does not give him an advantage and reduces the possibility of loopholes. However, this provision can be differentiated from those provided in India. Section 1 sub 2 of the Protection of Children from Sexual Offences Act 2012 only caters for offences occurring within territories of India, with the exception of the regions of Jammu and Kashmir. It unfortunately does not provide for offences committed outside these specific areas. This could be generally problematic as most predators targeting children most commonly use the internet to groom them. Most sexual predators and pedophiles use online social platforms or games to contact naive children and take advantage of them. Technology gives offenders access to children around the clock. The grooming of children for sexual purposes through the internet and related technologies is a growing problem worldwide, putting countless children at risk for sexual abuse and exploitation. The NSPCC reported that in England and Wales, the internet was used to commit an average of 8 sexual crimes against children, including rape, grooming, and live streaming of abuse every day in 2015. Another study of Swedish children media's habit found that 82% of children aged 9 to 11 and 95% of children aged 12 to 16 use the internet. 28% and 54% of those of the same age group respectively use the internet daily. This report demonstrates that children around the world have integrated the internet into their lives in a way that may still be incomprehensible to many adults. Children today use the internet every day not only to communicate with one another but also to establish and maintain relationships with others, their social sphere often spanning both online and offline without any clear separation between the two. Taking all that into consideration, this particular provision set up by Malaysia should be uploaded in the sense that it provides for the protection of children both within Malaysia and outside the territories of Malaysia. Another positive aspect of the laws pertaining to grooming is the capacity of children to be witnesses and give evidence. This is provided under Sections 17 and 18 of the Act respectively. Child witnesses are presumed to have the capacity to give evidence until the court thinks otherwise. This is therefore applied to instances involving child grooming. Under previous law, a court had to conduct a 2-tiered test first to determine whether the children understands what an oath is. If the answer was negative, then the court would have to ascertain whether he understands the importance of giving a truthful statement. Therefore, where a child has been subject to grooming or witnessed grooming of one another, they would be presumed to be competent persons capable of giving witness statement. Section 18 extends this right of a child by stating that the court may convict such person of such offences, that is, grooming on the basis of uncorroborated evidence of a child given upon oath or otherwise. This is especially important because grooming instances rarely ever happen in the open. Children are usually reluctant to inform competent adults either through pressure from the groomer or due to the fact that they may be ashamed or scared. It should be pointed out that the state set up a special court for these specific cases. According to the New Straits Times, the Special Court on Sexual Offences Against Children at Putrajaya, launched on 22nd of June, would focus on cases such as pornography, child grooming, and child sexual assault in accordance with the Sexual Offences Act Against Children 2017. The court sits only for cases of sexual offences against children, thereby expediting the resolution of these cases. By speeding up the court processes, justice is served faster and victims get closure faster too. Furthermore, the court is equipped with special equipment and toys to help children give evidence calmly and accurately. This is especially important as the victim's evidence is often the most crucial evidence in the prosecution. Lawyers in court will be provided with adequate training so as to ensure ethical approaches when questioning child witness. According to a Bernama report, a total of 56 cases from Kuala Lumpur, Putrajaya and Selangor have been transferred to the special court. On the other hand, the United Kingdom lacks in that particular area. The Sexual Offences Act 2003 of England and Wales does not mention taking in child statement, nor does it mention any special courts for dealing with cases of sexual abuse, child pornography or grooming. In such cases, while it is true that dealing with children can be quite delicate, it should be highlighted that an offence of such severity should be provided with all necessary evidence, including the victim's statement. Another positive aspect of the Act in general is that it disregards the requirement of proving that the sexual offense was committed when trying to prove grooming and meeting after grooming, as seen in sub 2 of both Section 12 and Section 13. Therefore, it is not necessary for the sexual predator to actually meet or have sexual relations with a child. The very fact that there had been communication with a child proves that the intention of the predator, thus making him liable under the relevant provision of the Act. Intention is therefore inferred.
Looking into another positive aspect of the 2017 Act, it can be argued that the Act clearly and unambiguously defines child grooming and what effectively amounts to grooming under Section 12. Illustration A under Section 12 exemplifies instances of online grooming and states that a person will be guilty of an offense under this section and is liable for a term less than 5 years imprisonment and shall also be liable to whipping. According to the new global terminology guidelines, that is, the Luxembourg terminologies, one of their goals is to bring about a consensus of the definition of grooming to be the process of establishing a relationship with a child, either in person or through the use of the internet or other digital technologies to facilitate either online or offline contact, sexual contact with that person. Indian laws, on the other hand, do not use the term grooming explicitly. However, they do have provisions for dealing with enticement of children. Additionally, the UK Sexual Offences Act 2003 uses the word inciting. The Indian Protection of Children from Sexual Offences Act on sexual harassment implies grooming through Section 11, Part 6, which deems the action illegal when someone entices a child for pornographic purposes or gives gratification thereof. Section 67C of the Information Technology Act also makes it illegal for anyone to cultivate, entice, and induce children to online relationship with one or more children for sexually explicit acts, or in a manner that may offend a reasonable adult. Failure to use the term grooming explicitly in these provisions led to a UNICEF report, namely Child Online Protection in India, which highlighted the inefficacy of Indian laws due to a lack of clear-cut and uniform technology in legislation and the risk of subjective interpretation of legal provisions. Thus, India and other countries that are similar in this regard could adopt the Luxembourg definition to ensure their country's understanding of grooming is in line with international standards. Since we've looked at the positive aspects of the OAC 2017, now we're left with the question: do the provisions provide enough protection for children against sexual predators? One area of obscurity which is worth addressing is the gray area of consent. As earlier mentioned, Section 2 of the OAC 2017 defines a child to be under 18 years of age, and the Act protects such a child from grooming. This causes confusion, as the Penal Code as under the Penal Code, an individual may engage in consensual sex with another person that is above 16 years of age, since statutory rape is enforceable for only 15 years and below. However, Section 15 of the OAC states that any person who touches a child for sexual purposes commits a crime which, bearing in mind the Act defines a child to be under 18. This raises obscurity in the law, as it leaves us with the question of whether an individual commits a crime under Section 15 if their partner is a 17-year-old who consented to sex. In the UK, the age of consent is 16. Section 10 of the Sexual Offences Act 2003 states that a person who incites a child to engage in sexual activity would be guilty of an offense if the child is below 16 and the person does not reasonably believe the child to be older than 16. The Act further adds protection for a child that is under 13. This is due to the possibility of an offender successfully escaping prosecution if it can be proven that the offender reasonably believed that the child was above 16. This risk would not be taken for a child below 13 years due to Section 10, subsection 1C, part 2. The UK Sexual Offences Act does not overlap with the age of consent. Instead, it offers greater protection for children under 13 years. On the other hand, it could be suggested that the Malaysian OAC 2017 should reduce the age of a child from 18 to 16 to fall in line with the age of consent in the Penal Code. Another issue to address is the need to enhance penalties for repeat offenders and increase the aggravated factors mentioned in the Act. According to the explanation of Section 15 of the OAC, in determining what constitutes sexual purposes, the court may take into consideration, among others, the words uttered, the nature and extent of the gestures, and all other circumstances surrounding the conduct. However, besides specifying under Section 13, that is the penalty for the occurrence of an online meeting, following the online sexual abuse, and Section 16, which addresses the penalty for the abuse of a position of authority and nature of prior relationship between the offender and the victim. The Act does not go further into the penalty for repeat offenders or other aggravated factors, which also encompass online grooming. Aggravated penalties for online grooming should be included in sentencing guidelines for various factors. Other aggravated factors include the age of the victim, the age difference between the offender and the victim, any physical and psychological injury suffered by the victim, the degree to which the offense was planned, the level of persistence in communication with the victim, the number of alleged victims, the sophistication of the online grooming process, the severity of sexualized content sent to or requested from the victim, and sexual extortion, including sharing or threat of sharing sexual images of the victim with others.
I will firstly talk about the harshness of the no age defense in the OAC. A general principle adopted by several countries is that presumption of age does not represent a defense for sexual offenses. The OAC holds the same principle. It is stated under Section 20 that an adult who believed the child victim was within the age mentioned in the respective provisions of the Act does not have the liberty of using it as a defense. Therefore, an adult who groomed a child, despite honestly believing that the child was of age, will be subject to an absolute liability. This harsh principle was upheld by some and criticized by others. For instance, in her dissenting argument in the Australian case R versus Hess, McLachlan, judge, explains the deterrence argument in support of the harsh rule. By imposing an absolute liability, the defense of presumption of age or due diligence would not apply. Therefore, an adult would have to take reasonable steps in ascertaining the age of the girl. If not, the risk of being liable under child grooming or other sexual offenses. McLachlan also pointed out that the defense of due diligence and presumption of age leaves possibility that the girl would lie about her age. This usually happens in cases of child prostitution. Therefore, the absolute liability enforced by the provision acts like a guard to this situation also. Additionally, the defense of mistake of age would be too accessible even when mistake is not found. In the same case, Hardiman judge criticizes the no age defense. Concerning deterrence effect of it, the judge criticizes it on the basis that there is no evidence to support such claims. Given the seriousness of grooming and other sexual offenses, there is a risk that an innocent mind may be found guilty and face potential life imprisonment. Therefore, evidence is still needed for the effectiveness of the deterrence effect. In the United Kingdom, the Sexual Offence Act 2003 allows the defense of presumption of age for grooming. It might be better for Malaysia to take the British approach given the current lack of evidence in support of the no age defense. Moving on to a second criticism of the provisions, we'll talk about mandatory reporting. Mandatory reporting is important for protecting children against sexual predators and reduce cases of sexual abuse. Many countries have specific laws concerning child grooming, for example, America, Canada, or Australia. This principle was already present in the Malaysian Child Act 2001 under the section 27, 28, and 29. It has also been introduced under the OAC 2017 under section 19. The punishment under the Malaysian Act is similar to India. Under the Indian Protection of Children from Sexual Offences Act 2012, section 21. Both impose a potential fine or imprisonment. In Malaysia, the imprisonment might go up to 2 years. However, as put forward by Norazla Abdul Wahab, the mandatory reporting might not be effective. inaccurate report is likely to make the reporter be sued by the victim's family. Given the severe punishment, some reporters give evidence which lacks factual basis. The Malaysian Act does not provide for the protection of the reporter, therefore discouraging people to report as they fear of being sued. Thus, the Malaysian Act can be improved by introducing legal immunity for the reporter who makes report in good faith and guarantee the confidentiality. The law could also be more clear and less severe on the punishment so as to reduce inefficiencies. All in all, the Act aims at protecting children. So we'll talk about how child grooming may protect in the issue of child marriages. Under both the civil law and Islamic law, girls can marry at 16, whilst boys are able to marry at 18. Civil law set the minimum age of marriage at 18, but those above 16 can be married with the permission of the state's chief minister. However, under the Islamic law, children younger than 16 can be married if the Sharia laws courts allow it. This means that by law, there is no minimum age for Muslims. The OAC aim is to increase the protection of children from sexual abuse, and it criminalizes sexual grooming as a prelude to sexual abuse and also spells out penalties for such offenses against children under 18. Ironically, the Act does not mention anything about child marriages. Therefore, the absence of ban on child marriage allows rape offenders to marry their victims and escape liability, as marital rape is not a crime in Malaysia. Sisters in Islam Executive Director Rosana Issa stated, "If there's nothing to prevent a child below 16 from getting married, how can we properly define and criminalize child grooming?" A former Sharia court judge stated that girls reach puberty at the age of 9 or 12, and that at that time their body is already akin to them being 18 years old. So physically and spiritually, it is not a barrier for the girl to marry. He further stated that there was nothing wrong with a rape victim marrying her rapist, as she would then not face a bleak future. The absence of a ban on child marriages is inconsistent with the purpose of the new OAC 2017, as it leaves a large loophole for rapists and sexual predators to escape liability.
In light of what has been discussed, it can be said that the government has made a commendable effort in drafting the OAC 2017, taking into consideration different ways of protecting children. This includes the current implementation of the Registry of Sex Offenders, which the government could use to monitor social media accounts of convicted sexual predators. However, there is still room for improvement in some areas, such as the area of consent, mandatory reporting, and child marriages. RAGE has come forward applauding this intention. However, they point out that only time will tell if it is effective practically as it is in theory. It is up to the courts to uphold the purpose and the intention of the Act. Furthermore, RAGE argues that while the provisions on sexual grooming are a step forward in the right direction, more awareness must be brought and the social stigma of sex should be dealt with. Alongside legislation, awareness campaigns should also be looked into, as well as the implementation of sex education in classrooms. On behalf of my group members, thank you very much.